Good morning, everyone, and thanks for joining this session on visa routes after the offshore wind concession ends. So for those of you who don't know, I'm Elaine McIlroy. I'm one of the partners in the Employment and Immigration team at Brodie's, and speaking alongside me today is Erin McLafferty, who's one of the associates in the team. And I'll just run through briefly then the agenda for today. So we're going to start with the offshore and offshore wind immigration concession, and we'll explain what that is. It was originally intended to end at the end of October last year, and we had originally planned to do this webinar around that time when we thought that it was all coming to an end. But the UK government announced last minute that it was going to extend the concession until April, the end of April 2023. So we'll talk a bit about what the concession is, who can use it, etc. And hopefully this session is good and useful in terms of timing because of that concession coming to an end. And the purpose of the webinar is to explore what alternative visa routes might be available to you when that concession ends. Lots of employers have been relying on it for many years now. And each of the visa routes that we'll talk about today have got their own criteria. Not every route will suit every employer or every job role or every nationality in terms of your staff, but we'll hopefully outline some of the key routes that you might want to consider if you're looking at alternatives to having used the concession. It's worth bearing in mind as well that in addition to the routes we'll talk about today, there are lots of other visa routes out there. We're not going to have time to cover every route under the sun. So bear in mind, we're just talking about a few of the key ones, but for your circumstances, there may be others which are useful. And today is just an overview of the routes. So if you're interested in the nitty-gritty and the detail, all of that is available online on the Home Office website, or you can take advice, of course. So let's get started then with a bit on the background. So the UK offshore wind industry currently employs 27,000 people based on certain estimates, and I know there's different estimates out there, and it's anticipated to grow really significantly. So one of the estimates was that by 2030, there would be around 100,000 people engaged in the sector. And the sector does also have a significant reliance on foreign workers. So anyone who's not British and Irish now needs some form of permission to work. So either a work visa or permission on some other basis. And therein lies the challenge for the sector in terms of finding ways of employing people who aren't British and Irish in the UK. The UK immigration rules apply to the UK mainland, of course, and also within a 12-mile nautical mile radius of the UK, which is sometimes referred to as UK territorial waters. So anyone working within the mainland or those territorial waters needs some form of permission to work under the immigration rules. And the UK government introduced the Offshore Wind Workers Concession in 2017. So it's been around for quite a few years, and it actually did significantly predate Brexit, but it's become more important to people because of the Brexit restrictions once freedom of movement sort of fell away. And it was introduced to recognise the importance of wind farms in the UK to basically allow the employment of certain qualifying foreign nationals who were joining vessels engaged in the construction and maintenance of offshore wind projects in the UK and territorial waters. And they basically didn't need a work visa, a standard work visa, in order to work. Instead, they could rely on this concession, and we'll talk a bit about what paperwork, etc., was involved in that in the next slide. But when announcing this last-minute extension to the concession to the end of April 2023, the government has made it clear, and they've said this before, that it's the final extension, but they've said this is the final extension, and they've given a warning shot to employers that they should consider alternative ways for people to obtain permission to work in the UK. So there is no indication that it's going to be extended beyond the end of April. Employers therefore need to find alternative solutions, and it makes sense to use this time that you've got in order to find alternative work permits, etc., that will be a long-term solution. So if we just move on to look at the details of the concession itself. It's a concession outside of the immigration rules, and it allows or gives individuals leave to enter to do the work in question. The intention in terms of the cut-off date of the end of April 2023 is that that is a hard cut-off date. So people will only be given leave up to that date in April. It won't be possible to say bring in a whole bunch of people before that April date and then let them stay beyond it. It is likely to be a hard cut-off. And in terms of what the wording of the concession says, it says it applies to workers who are essential to the construction and maintenance of offshore wind farms in UK territorial waters. And the individuals concerned should be joining vessels engaged in the construction or maintenance of offshore wind projects. The real benefit of the concession is that in terms of process, paperwork and costs, etc., it's been extremely straightforward. In most cases, no visa is required for visa nationals who come from a particular list of countries. They might need a visit visa, a transit visa, but other than that, there are no costs involved. There's very little paperwork. The individuals would carry a letter from their employer explaining what activities they are coming to the UK to do, but there was no requirement for sponsor licenses, for the business to have a presence in the UK, etc. So lots of benefits of the route. One slight downside is that time spent in the UK under this route doesn't count towards residence or settlement in the UK. So even if individuals have been using this route for several years, they're not going to be able to apply for indefinite leave to remain, for example, as an alternative route. So the paperwork that's needed at the moment is, as I said, the letter from the employer explaining the activities and also a passport. And then for those visa nationals, they may need to apply for a transit visa before coming. Another benefit of the concession is that there is no English language requirement, and lots of workers who maybe wouldn't be able to meet that requirement, which applies to alternative visa routes, have been able to therefore benefit from this concession. But it's been very straightforward, etc., until now, but that is all likely to be coming to an end at the end of April. So if we just move on to the next slide, we're going to run through today then some alternative visa routes. Lots of businesses are asking us for advice about what else they can put in place when this concession ends, or in light of the fact that it's coming to an end. So today we're going to touch on frontier worker permits, which may be suitable for certain categories of people, the skilled worker route, and senior specialist worker category that used to be known as intercompany transfer route. We're going to touch on a slightly more new route that some people might have heard a bit less about, the Global Business Mobility Service Supplier route, but that might be a solution for some businesses that can't get their own sponsor license because they don't have a presence in the UK. And then Erin's going to touch on some options under the business visit route. That's doesn't generally permit work, but there's some categories that allow short-term visits to the UK for the purposes of certain work-related activities. So she'll cover off those, which may again work for some businesses depending on what you need people to do when they come. So starting then with frontier worker permits. This type of permission to work was introduced in December 2020 as a result of the Brexit arrangements. So as part of the withdrawal agreement and the separation arrangements, it was put in place basically to preserve certain free movement rights for certain cross-border workers who'd come to the UK either for employment or self-employment before the end of the Brexit transition period. And it was for people who lived outside the UK primarily, but came to the UK for work. And just as the EU settlement scheme preserved free movement rights for those already living here, this was to preserve their rights as cross-border workers to continue to do that after the Brexit date, as long as they had done it before the end of the Brexit transition period. So the key requirements are that the individual's an EEA citizen. They need to prove that they're primarily resident outside the UK, and there's guidance about what that means. But it's pretty loose criteria in terms of satisfying that. The individual must demonstrate a period of work or self-employment in the UK in the 12-month period before the Brexit transition period ended on the 31st of December 2020, but there are some exceptions to that, which I'll talk about in a minute. And the individual also needs to show, excuse me, that they continue to be a frontier worker, so that they continue to come to the UK for employment or self-employment at least once every 12-month rolling period from their last period in the UK before the Brexit transition period ended. There's lots of detailed guidance online if you're actually looking at making an application under this. And it's worth saying lots of people actually fail to meet the sort of criteria that I've just outlined there because of COVID. So some people stopped coming to the UK for certain periods of time, either in the lead up to the end of the Brexit transition period or in the 12 months afterwards, because there were lots of travel restrictions, etc. in place. And there is special guidance and concessions available if somebody can't meet those criteria because of COVID related reasons or because of long-term absences due to maternity sickness, etc. So there are exceptions if you can't meet that criteria, but you were coming to the UK for work or self-employment before the Brexit date. The good news about frontier worker permits is that the application process is free. There's no visa fees to pay. There is no immigration skills charge, which is a significant saving for employers. There's no NHS surcharge for the individual to pay. No English language requirement, so flexible from that perspective. And the individual will generally be given a 5-year permit that they can then extend, provided that they do continue to be a frontier worker. So it's a great application for those who do qualify. The main downside is that not everybody will qualify. They may not have that history of having worked in the UK and they might not meet the criteria. If individuals want to get this type of permission when the concession ends, they should go ahead and do that as soon as possible. There's an online application form. In some cases, supporting documents are uploaded, and in some cases there may be queries, etc., to deal with. But some applications are dealt with in a matter of a few weeks, but you would want to make those or get your workforce to make those applications sooner rather than later. Other good news about this type of permit is it's not tied to particular job, salary, etc., or a particular employer. So there's lots of flexibility in there for those who do qualify. I'll just hand over to Erin at this point, who's going to cover another route.
Great, thanks, Elaine. So I'm going to now look at the skilled worker route and a couple of other routes under the UK's point-based system. The first one is a skilled worker route, which some of you may be familiar with on the session today, and this is the kind of common route that employers would use in the UK to sponsor migrant workers to work for them. This is for skilled workers who have a job offer, and the employer in question must be registered with the UK Home Office as a licensed sponsor under this route. That process can take up to 8 weeks. In order for UKPI to consider the application. So it is important to think about that timing, and there might be a little bit of timing involved in getting your application together. It does involve an online form to be completed and submitted, and some paperwork to be collated and sent away to the UK Home Office. One of the key challenges with this route for overseas employers is that if you do not have a UK entity or permanent personnel in the UK, this could be problematic. You must have a UK subsidiary or overseas registered branch in the UK in order to make a valid skilled worker licence application. And there are certain roles within the licence that need to be fulfilled by UK-based staff, usually who are settled workers. And if overseas companies do not have that kind of infrastructure in the UK, then the skilled worker route may not be an option for them. But there may be other options available, and I'll chat through them a little bit later in the session. In terms of who is eligible to be sponsored under this route, it's usually those who are doing medium or highly skilled jobs, and I would note low skilled jobs are not eligible under the skilled worker route. There are salary thresholds as well, so individuals usually need to be earning £25,600 per year or the going rate for the job, and UKVI do publish job codes for the roles that they see as being eligible for sponsorship. We've put some on the slide there that may be relevant to the sector, but there are also lots of engineering job codes within the list, and it is worth having a look at that if you think the skilled worker route may be appropriate for your organisation. Although there is that minimum salary of £25,600, I would say that there are certain exemptions in relation to that, and in some cases you can pay individuals as low as £20,480 per year, and they may still be eligible for sponsorship. So I guess it is important to consider the rules if any exemptions apply, and don't just necessarily discount a skilled worker sponsorship just because you're not going to be paying a salary within that threshold that I mentioned. It's always worth considering if an exemption does apply. There's no maximum period of leave under this route, so it does mean that employers can continue to extend individuals' visas for as long as they require them to work for them in the UK, and it can also be a route to settlement for individuals, and that can be a big advantage for the worker in question. It gives them the comfort of knowing that they can make the UK their home in the long term, but that can also be a big advantage to UK employers if you want to have the certainty that you can potentially have that worker remain in the UK permanently to work for you. There are English language requirements under this route, And that means that individuals who are applying for the visa must satisfy UKVI that they can speak English to a certain level, and that does usually involve sitting an English language test that's approved by the UK Home Office or having been taught a degree or similar in English. That sometimes is problematic under this route, and it is worth considering if you're going to use this route whether the individuals you will sponsor can meet that requirement. If the individuals from an English-speaking country, then normally they don't have to do anything further in relation to that requirement. There's also no resident labour market test and no limit on the number of visas that are granted under this route, and that does mean that it's much faster and more certain than it ever has been in the past. But it is important to still factor in time for this route if you plan to use it when the concession comes to an end. Once a licence is in place, or if you already have a licence in place, sponsorship itself of the migrant worker can still take 4 to 6 weeks on average. In some cases it can be faster, and in some cases it can be longer. And there are priority services, but I guess the key takeaway on that is timing is still important and should still be factored in. On the next slide, we've got a bit of a kind of timetable to just talk you through some considerations in relation to process. So if you need to apply for a sponsor licence, as I said, that could take up to 8 weeks to process. There may be options to expedite for an additional fee, but I would say always factor in 8 weeks. And if you get it faster, then that's great. And nothing is lost in relation to that. You do need to ensure the jobs that you want to sponsor are skilled enough and pay the appropriate rate, as I mentioned. Once the licence is in place, employers need to apply for and assign certificates of sponsorship. And I'm not going to get into the detail of certificates of sponsorship on today's session, but they can take anything between 1 working day and up to 18 weeks to process. So that can be an important timing to factor in. But in most cases, if you're going to sponsor an individual who's overseas to come to the UK for the first time, you are looking at the lower end of that kind of timescale I mentioned. So hopefully more in relation to 1 working day than 18 weeks. But it is important to consider that in your process. Once a certificate of sponsorship has been granted, the individual will then make their visa application under this route. That on average takes around 3 weeks, but at the moment it can take longer, particularly in certain jurisdictions, and that's just due to volume of applications and also certain IT-related issues that the Home Office are experiencing. So the key takeaway from this is that if you were to apply for a sponsor licence today, if you didn't already have one, it could be early to mid-April in order to complete this whole process and to get your first migrant worker in the UK under the skilled worker route. So if you are thinking about skilled worker, or if you think it could be an appropriate alternative when the concession comes to an end, you should be thinking about it now, because actually it could take up to April to get all this resolved, and the concession is obviously due to end at the end of April, so it doesn't give you lots of time. There are also costs to consider. The concession that Elaine mentioned is free in most cases or has very low fees and paperwork. That's not the case for skilled worker route, and there are some costs that do need to be factored in. I've got them on the slide there, and I'm not going to go through them in lots of detail, but you will see there are certain costs to get the sponsor licence itself. There is also the immigration skills charge, which is like an employer tax, and that's usually payable per year of the visa. So if you're getting a 3-year visa, you will pay that fee based on the 3 years up front. There are also then visa costs and health surcharges. I guess some of these fees fall to the employer as default, but in lots of cases the employer will cover all of these fees if they need to bring the migrant worker in. But again, it's just important to factor that into your budgeting. If you're going to use a skilled worker route as an alternative, there may just be costs to consider in relation to that process. Next, I'm going to talk about the Global Business Mobility Senior and Specialist Worker route, and that was formerly known as the Intercompany Transfer or ICT route that you might be familiar with. This is for senior managers or specialist employees who are working for a multinational business based overseas that has a UK entity. And it envisages that UK entity bringing those overseas employees into the UK to do specific work or jobs. It does require the UK entity to have a sponsor licence, and that's different to the skilled worker licence and does involve different paperwork to be put in place. If that licence isn't already in place, the timing is pretty similar, as I mentioned, under skilled worker route, but there is no option to expedite. So bear that in mind. You are looking at 8 weeks usually in total to get that licence once you've submitted the application. This is a temporary route, so it doesn't lead to settlement, but individuals can be in the UK for an initial period of up to 5 years. That can be up to 9 years for high earners, but I guess after that initial 5-year period, individuals must usually leave the UK for at least 12 months, so important to bear that in mind. It doesn't lead to settlement, so that means you don't have that option for individuals to switch into indefinite leave to remain in the long term under this category. It also only applies to individuals who are doing highly skilled roles. So medium skilled roles and low skilled roles do not qualify. That's different to skilled worker, where medium skilled roles can be sponsored. And there is a higher minimum salary of 42,400, or the going rate for the job in question. And usually the individual must have at least 12 months service with the overseas company. So immediately it is a much smaller pool of employees that will qualify because that skills and salary threshold is higher. But one of the big advantages to this route is that there is no English language requirement. So where you're looking to sponsor someone who may struggle to meet that English language requirement, perhaps under skilled worker, you might want to consider the senior and specialist worker route if they qualify. It may be an alternative option for those individuals, and that is a big advantage of the category. In some cases, there may also be cost savings under this route. So if you're going to sponsor an EU national who's employed by an entity established in the EU, and that's one of your group companies, and you're going to bring them to the UK for around 3 years, 36 months, you may be able to make a saving on that immigration skills charge. So again, that can be a big cost saving and can be a reason why you might consider ICT over skilled worker, for example. Next, I'm going to talk about another global business mobility route, and this is called the service supplier route. And this is new. It's only opened in the last year, opened in 2022. And this route's for overseas companies who want to send employees to the UK to work pursuant to a contract they have in place to provide services to a UK company. And the main difference between this and the other two routes I've mentioned is that it's for overseas providers or employers who don't have a commercial presence in the UK. So skilled worker route and the senior and specialist worker route both envisage or require actually the a company to have a UK presence and a UK company that can apply for a sponsor license. This route's for those overseas employers who don't have a UK presence. And therefore, what that requires is for the UK company in that contractual scenario, so for example, the client, to obtain a sponsor license and to then sponsor the eligible migrant workers. The sponsor license does cost here, so it's £536. And to apply, the UK client must submit an online form and send a copy of the contract for services in question and details of the overseas employer. And I would say that the contract here does have to be granted through an open tender process. So that is important, and important to remember if you're going to send the contract away, that is how it has to have been identified. This route does have lower costs than the other two routes that I mentioned today. So the certificate sponsorship cost is lower and the visa cost is lower. There's also no immigration skills charge. So again, can be a more cost-effective way to sponsor individuals. But it does take around 8 weeks to get the license, as with the other routes I mentioned, and it is temporary. So usually it's for assignments for around 6 to 12 months, depending on the circumstances. To qualify, individuals must have usually worked for their overseas employer for 12 months, and they must be providing services pursuant to a contract that's covered by a valid international trade agreement. And the trade agreements that qualify are all mentioned in the rules, and I won't get into that in lots of detail today, but it does include things such as the UK and EU withdrawal agreement that was concluded following in relation to Brexit. I would say that what that means is that only certain types of jobs and sectors are covered, and it is important to take advice or to double check if there is a valid international trade agreement that applies. It's also only highly skilled roles that have a relevant job code, or individuals who've got professional qualifications or degrees or hires in the particular sector they're going to be working in, and usually they have to have around 3 years professional experience. The key thing for the UK company, so the client, to consider is that you will have to confirm that you're going to be responsible for the duties, functions and outcomes and outputs of the job that person will be doing. So you have to be comfortable taking that responsibility on, and you will have compliance obligations in relation to that individual. So you will have record keeping obligations and compliance obligations, for example. So it can be an alternative route in some circumstances, but it is important for the UK company to be happy to take on those obligations. And finally, I'm just going to really quickly mention the business visitor routes. As Elaine mentioned, these are not an alternative to work visas, and that's because visitors cannot usually work in the UK while they're here as a visitor. They can carry out certain permitted business activities, but there are some exemptions to that kind of working in the UK. I would say in most cases it's usually better to find a different visa if possible, or look for a work visa, because it just gives you more certainty. They tend to be longer term, and it means you don't need to be quite so concerned about individuals crossing thresholds into working, etc. Some of the areas to look at are intercorporate activities, which are for employees who work for an overseas group company and are going to come to the UK to carry out certain activities with the UK entity of the same corporate group. That can involve advising, consulting, troubleshooting on an internal project, but no work if you're relying on these specific areas of the rules can be done with clients. So that can be a limit in some cases. If you're going to have individuals come to the UK and work with or alongside clients, then the intercorporate activities element of the rules is unlikely to be appropriate. There's also the manufacture and supply of goods, the UK element of the business visitor rules, and this allows overseas companies who are supplying certain software, equipment, or machinery to UK companies to send an employee over to the UK to install, dismantle, repair, advise in relation to that machinery. So it can be helpful in some cases, but again, that would be an option usually only where those visits are going to be quite short term and not super frequent or repetitive. EU citizens do not normally need to apply for a visit visa in advance, but they should carry a letter with them confirming the specific rules they're relying on. And I would say it's critical for the UK host to consider what area of the business visitor rules they are relying on and take advice if they are not sure, because they are very specific and not very clear about what individuals can and cannot do. And I would say repeat or prolonged visits can sometimes lead to scrutiny at the border. So having that letter is important to explain what they're going to be doing. And in some cases, individuals may want to apply for a visa in advance to gain that certainty that what they're doing is permitted. Where the individual's a visa national, they will have to apply for a visit visa in advance. So they will have to go through that process regardless. But business visitor rules can in some cases be appropriate and easier and quicker for short kind of assignments to the UK. I'll hand over to Elaine. She's going to chat through some case studies to hopefully bring this to life a bit.
Yeah, just briefly, because we'll hopefully get onto the questions in just a moment or two, but we thought we'd just compare and contrast a couple of different scenarios, to put a bit of colour around what we've talked about so far. So in the first example, we've got an overseas company that wants to continue to send employees to the UK to work. They will be involved in offshore wind projects, and the company doesn't have a company in the UK. In this case, they currently send employees into the UK for a month or so at a time using the concession. They are considering sponsoring employees under the skilled worker route that Erin talked about. They decide to go ahead and set up a UK entity. They take advice from a corporate and tax perspective about the pros and cons before deciding to go down that road. But they decide to set up the company and hire a local operations manager in the UK who's British. He can then go ahead and apply for the sponsor license and can act as their key personnel for the license. So he can be the authorising officer for it because he lives permanently in the UK. He hires an HR manager who will help with the reporting, etc., and record keeping for the sponsor license. In this case, it takes the company a few weeks to get the paperwork that they need to go ahead and get the license. So they need to get a bank statement to register with HMRC, etc. They go ahead and apply. It takes 8 weeks to process the license application. They get a compliance visit, which can happen in some cases, and that they pass, so they go ahead and get their license. And they decide in this case to apply for the senior and specialist worker category on their license as well, so that they've got the option to sponsor under both, because they've got some individuals who might not meet the English language test, so that gives them additional options. In this case, they've got a number of low-skilled workers. They wouldn't qualify for sponsorship under the skilled worker route or that senior and specialist worker category, but they may be able to go for frontier worker permits for those individuals. So that maybe gives you an example where more than one route, maybe actually 2 or 3 of the options we talked about, might provide an overall solution in terms of the workforce. And if we just compare then this case study with the second one and the final one, In this case, we've got another overseas business that contracts to provide services to UK business, and the staff that they send will be involved also in offshore wind projects. They don't have a UK presence. They have been using the wind concession as well to send employees to undertake qualifying work. And they decide that in this case, they don't want to set up a UK entity, so it's an alternative approach here. That means the skilled worker route's not an option, neither is the senior and specialist worker category. So they're instead looking at other options so that they can continue sending overseas workers to the UK to continue servicing their UK clients. They look at different options under the business visit rules, which may provide a solution for some people on a short-term basis to do those limited activities under the manufacture and supply of goods provisions that Erin mentioned. They've also got some European citizens who worked in the UK before Brexit. So again, they may qualify for frontier worker permits for some of the individuals. They can do the low-skilled jobs as well as those medium and highly skilled ones, and gives them a 5-year permission to work and also saves them costs. And then the company is also looking into the contractual service supplier route that Erin talked about. That would depend on whether their client might be prepared to undertake those compliance obligations and be able to be responsible for the outputs of the job, etc. So they're looking into that as another option. So hopefully those two demonstrate different scenarios where there isn't a presence, where you've got different options available to you with different sort of pros and cons. And I'm conscious we're running out of time, so we'll maybe just quickly go for a couple of questions. And if you do have any, please do put them in the box and we will get back to you if we don't have time to get to them today, but we'll just run on for a minute or two to get a couple of questions in.
Okay, so we have had a question come in and someone's asking, we have a vessel operating within UK waters within the 12 nautical mile radius of UK mainland. They're doing research work for potential wind farms. Will the individuals, the crew members, require work visas?
So I don't know if in this case the individuals have been using the concession to come to the UK, but if so, yes, there needs to be a plan in place for what happens after that concession ends at the end of April. Does research work come under the construction? Anyway, there needs to be some sort of form of permission to work there. That might be one of the options that we talked about. And there are also there's an additional sort of set of rules for people working in territorial waters that we would look into. So I think that's probably a bit of a complex one for today, but we'll maybe come back to you on that one separately. Erin, I've got one here for you. Can a UK company sponsor individuals to work in the UK who are employed by an overseas company, for example, the UK company's client under the skilled worker route?
So the skilled worker route does normally envisage the people or the individual that they sponsor being their employees, but there are some exceptions to that rule depending on the circumstances. I guess ultimately the UK sponsor under the skilled worker route does have to have responsibility for all the duties, functions and outputs of the role, and they should be happy that that's the case in relation to sponsoring them. There doesn't necessarily need to be a direct contract of employment in place, but you would expect there to be something that demonstrates that control and I guess responsibility for the duties of the role. So it is important to take advice on that if you're thinking about potentially sponsoring an individual that you don't directly engage, because there are specific rules and specific guidance, I guess, in relation to that under that route.
And I think the Home Office say they scrutinise that sort of arrangement much more closely. So yeah, I think you'd need specific advice if you were relying on it on that basis. Well, I'm just going to finish off there since we're a few minutes over, but thank you for joining today. There is a feedback form that will pop up. That's really helpful for us if you could complete that. And as I said, the recording will be sent out later and we'll come back to you on any questions we've not been able to deal with today. Thank you.
Thanks.